Mr. Barr, whenever you're ready.
Good morning. May it please the court. My name is Chad Barr, and I have the pleasure of representing Air Quality Assessors of Florida in this case. For the court's convenience, I'll just probably refer to them as AQA throughout my argument.
Okay.
I just want to say I've got the first district's background in my profile, but I look forward to the court having its own courtroom soon and being able to visit that for oral arguments in the future.
I hope it looks that good.
Yeah, be great.
All right. Well, thank you for having us. Thank you for allowing us to appear via Zoom. I know it's a great convenience to everyone. We're here asking the court today to reverse the trial court's order of dismissal, primarily for three reasons. Judge Kelly, I will reserve my 5 minutes for rebuttal.
All right.
But the three reasons we're asking the court to reverse are that first, the trial court went beyond the four corners of the complaint when it considered an assignment of benefits agreement attached to the motion to dismiss. The trial court improperly resolved disputed issues of fact at the motion to dismiss stage, and the trial court allowed the appellee to challenge the legal effect and validity of two assignment agreements, neither of which the appellee was a party to or was a third-party beneficiary to. I'll start with the first issue. I think it's the easiest one. It's the one that's most important to the appellant in this case. And I think we start with the law regarding what the court can consider and what the court can do at a motion to dismiss stage is very well established here in the state of Florida. First, the trial court must accept all well-pled allegations as true. All reasonable.
Well, I'm sorry to interrupt you, Mr. Barr, because I know this is an important argument to you, but I think we all understand that principle. The appellee's response to that is, well, hey, we're in county court and there's this summary procedure that's available, and let's just say we did that. And so if we leave aside, and I do understand your argument, but leaving aside the problem about staying within the four corners of the complaint, when you look at the assignment I'm sorry, was it River?
From air quality to restoration.
Restoration, okay. When you look at that assignment, it says that AQA has irrevocably assigns and transfers to assignee all right, title, and interest to the AOB and the rights and benefits arising from it. And, you know, and then it goes on, and then it says past, present, and future rights that the assigner has or may have, and that all other rights arising from or relating to the services. So how would you ever get around that language in the assignment?
Very simple. There's some issues that we have to look at with regard to what the assignment says and what it applies to. So first of all, we have to look at the fact that the assignment agreement that they've attached to their motion to dismiss does not identify the claim that is identified in the assignment of benefits that's attached to the complaint. All right, so there's an issue with regard to that. So without any substantiation of the assignment of benefits from AQA to restoration, there's an issue there that has to be dealt with. The other issue is the assignment of benefits that's attached to the motion to dismiss. I'll just call it the second assignment of benefits, just for ease of conversation.
Right.
The second assignment of benefits does not identify what the services are. Now, why that's important is because this second assignment was executed before the services air quality provided in this case. So this assignment of benefits was dated January 18th, 2019. The services that air quality provided in this case were provided in April of 2019. So almost 3 months after the second assignment was entered. If you look at this assignment and read through it, everything is in past tense.
Well, it says past, present, and future rights.
Past, present, and future rights regarding the services provided. So the services provided in the past. So any rights that arise from the services that were already provided as of the date of the assignment of benefits. So if you look at it, everything is in the past tense. And so we have that issue that would need to be resolved. The defendant, they attached affidavits, of course, after the court had already ruled on the motion to dismiss, but the defendant attached affidavits from both restoration and air quality saying that the assignment of benefits did not encompassed the engineering report that air quality provided in this particular case. So it was regarding the services already provided, not regarding services that were yet to be provided. Any reference to future dealt with services, future rights regarding services that had already been provided.
Okay,
So
I understand. Thank
all
you.
right. And the other issue with that whole argument is they didn't move for summary disposition at the moment that they filed their motion to dismiss the amended complaint. They filed a motion to dismiss, and the courts have been very clear. And while the appellee does a great job of telling us what a summary, or excuse me, what a small claims case is and why we have them, it does nothing to demonstrate that the court can consider a summary disposition at the same time it's considering a motion to dismiss when there are issues of fact that have to be resolved. And the courts, if anything, equate a motion for summary disposition with a motion for summary judgment. So if the law in Florida is that a motion to dismiss should not be treated as a motion for summary judgment, then certainly a motion to dismiss should also not be treated as a motion for summary disposition. So we have those issues that have to be merited out or ferreted out in this case. The other thing too is that you know, the appellee brings up this argument regarding the parole evidence rule, and I just want the court to understand that our position is steadfastly that the parole evidence rule does not apply when it's an outside party trying to challenge the validity of a contract. So when we have two contracting parties saying we agree what the intent of this assignment of benefits was, the outside party, in this case Florida Farm Bureau, they cannot use the parole evidence rule to prevent two contracting parties to clarify what they meant by an assignment of benefits. So long way. I hope I answered your question.
You did. I appreciate it. Thank you.
No problem. And so we've got the issue of the just stepping back to the first issue briefly. We've got the court taking a document that's not attached to the complaint, that's not referenced in the complaint, and upon which the AQA's claim is not dependent. So if you look at the answer brief, I think it's very telling. The only two cases that the answer brief relies on are this court's opinion in Veal versus Voyager and the 4th District's opinion in the one call case. And both of those cases concern this doctrine called the incorporated or impliedly incorporated by reference doctrine. It's a very, very narrow exception to the four corners rules. It's never been applied the way that the appellee is asking this court to apply it in this case. And I would suggest that there's no support for this court expanding that doctrine.
Let me just ask you, Mr. Barr, was there any legal support for the implied incorporation doctrine at the time this court adopted it?
Not in the opinion. Certainly.
Yeah, I didn't see it.
So, and I think that if we look at this court's subsequent rulings, specifically we look at the landmark funding versus Chalut's case, it seems to really be putting that exception back into its box and saying, you know, this is a very, very limited exception. And to some extent, I kind of understand it, but in reality, in this case, it doesn't apply, and there's no basis to extend it beyond what the court held in both the Veal and the 4th District held in the one call case. And so I think understanding the very strong differentiation and distinction in those facts is very important to understanding why those cases are just absolutely inapplicable in this case. I do think the landmark funding case is the case that's most on point with the issue in this case. In that case, the defendant was challenging the plaintiff's standing. And what they did was they asked the court to consider statements made by the plaintiff in a separate proceeding in order to defeat the issue of, in order to defeat the plaintiff's standing in that case. And this court reversed the trial court's order dismissal and held that the doctrine of implied incorporation by reference has no place where the proceedings, and those proceedings where those contradictory statements were made were not referenced in the complaint, and where the plaintiff's standing was not dependent on those statements. Our standing in this case is not dependent on that second assignment of benefits. Now, while the appellee may argue that it defeats our standing later on, our standing is not dependent on the existence of that second assignment of benefits. I also just want to point out that yesterday I did file a notice of supplemental authority, and I apologize for filing it late, but just last week, the 5th District Court of Appeal entered an opinion in KC Wellness versus Direct General Insurance Company. And while the facts in that case were regarding a much different issue, The reality is what the rationale and the reasoning is directly applicable to this case. And in that case, the medical provider in a PIP case filed suit as the assignee of a patient against Direct General, asking or seeking PIP benefits under an insurance policy. Direct General filed a motion to dismiss, and they attached the final judgment that they obtained against the named insured in a separately filed deck action, claiming that the final judgment voided the insurance policy ab initio. And the trial court accepted that final judgment, and they found that that the claim was moot, and they dismissed the lawsuit. And the Fifth District reversed. And while I would have really liked to see them address some of the more substantive legal arguments, what they really honed in on was the fact that the final judgment attached to the motion to dismiss was not attached to the complaint and was not referenced in the complaint, and therefore the trial court erred whenever it considered that document and attached to the motion to dismiss, and essentially was the basis of the order of dismissal. In this case, the motion to dismiss nor the answer brief argue that the allegations of the complaint are insufficient to state a cause of action. So without considering the second assignment of benefits, if we look just at the complaint, they sufficiently state a cause of action. The only way that we get to any argument about that is by considering this additional document that is not attached to the complaint, not referenced in the complaint. Therefore, the doctrine of implied incorporation by reference does not apply in this case, and this court should not extend it. There's also this issue of the disputed issues of fact. So again, I think discussing earlier with Judge Kelly the issues with the assignment of benefits, the services being provided after the second assignment of benefits, the second assignment of benefits only addressing services in the past, regardless of how it defines them. Regardless of its use of the word future, it's only regarding services done in the past.
Mr. Barr, I just want to, I did try to look through the record to find the date of the services for that you filed a statement of claim on, and there is an invoice, but you can have the date of the invoice, but I don't see a date of service. Can you direct me to where in the record it shows the date of service for the engineering report?
Judge, while Mr. Schulte is giving his argument.
Yeah, you can, that's fine. Do that on rebuttal, but I don't remember being able to find it.
No, and generally our services are dated the date of the date of the invoice, but I'll look through the amended complaint and see.
All right, and am I understanding the record correctly? This invoice was dated, I think, in April 4th, maybe early April.
Yes, April.
And you file, and I think it gives 30 days to pay, but this state claim was filed within days of the invoice being sent.
Well, there's no statute that gives them 30 days to pay.
No, I'm looking at the invoice, what the invoice said. I thought the invoice gave them time to pay, but it looks like the invoice is dated in early April, like maybe like a week later, the statement of claim was filed.
The date of the assignment, the date of the invoice is April 4th, and the lawsuit was filed on May 3rd. So
okay, all right. So about 30 days.
Yes.
Okay.
I've made the arguments that I wish to make. I'll reserve my 5 minutes for rebuttal.
Okay, great. Thank you. All right, Mr. Schulte.
Good morning. May it please the court. First, I'd like to correct some of the references to the documents and the record. The first one was the appellant stated that it was the appellee that filed the affidavits of Mr. Kidwell and Mr. Valero in the court below. It was the appellant AQA that filed those affidavits. So it was the appellant that injected those affidavits into the record.
But those were after the court had already granted the motion, right?
The motion was granted the first time, then this court remanded it back for reconsideration by the court.
No, I think we remanded it for entry of an appealable final order, because the order granting the motion dismissed does not vest jurisdiction in this court.
Okay.
So it needed magic words.
Okay, between the time of the first motion to dismiss, the first order granting and the second order granting, that's when the record evidence was prepared. because
Okay.
the second order was
Yeah, I
entered on-
understand that. I
Okay,
understand
okay.
that.
The second item is in the assignment itself with respect to what it states on paragraph, the
Which
second.
assignment? Which assignment?
The second assignment, Your Honor.
Okay.
The record number 608, the assignment from air quality assessors to the factoring company Restoration Claims 2 LLC. The second whereas agreement specifically states that at the end, that the assignment of benefits is attached to and made a part of that second assignment. So they have consolidated the initial assignment into the second assignment by signing this document with Restoration Claims 2. And that's part of the continuous chain of assignments that is the reason for the defendant's position.
Mr. Schulte, isn't the fact that you're bringing in and mixing and matching all these outside documents that aren't part of the complaint, isn't that just kind of proving the appellant's point that this really should not have been resolved on a motion to dismiss?
That would be the case if this were not proceeding under the small claims rules, but I also believe that there should be an exception to the motion to dismiss.
The small claims rules don't supplant the general rule about a motion to dismiss, right? Help me out with that.
The small claims rules have specific rules for informal procedures of determination.
But which you never implicated. I mean, here's the thing that's troubling about that. It's one thing to argue a tipsy coachman basis of affirmance based upon some kind of fact that's put before the court that, hey, even if you ruled wrong this way, these facts would have given rise to another ruling another way. But we don't usually extend that to where an entire procedure was utilized without even a point of entry of request by one of the parties. You're kind of asking us to do some, forgive the religious reference, but some transubstantiation of what happened below. Judge Kelly will appreciate that. That's very troubling because when you, as a lawyer, as a litigant appearing, especially in a small claim proceeding, which is supposed to be kind of fast moving, you at least need to know what kind of proceeding you're going under. And you're asking us to, after the fact, change what had happened below. What basis of support in the law do you have for that?
The basis for support that I would cite to would be the principle that looking to the substance of the motion and not the title is something that the appellate court should look to, and also what I believe the trial court did when
your title and your motion said dismiss this complaint. But you didn't implicate the summary proceeding rule.
Your Honor, the summary proceeding rule is something that can be done under the Florida small claims rules. I don't believe it needs to be specifically invoked by the party. If I look at the rule, I believe that the small claims rule is something that the court can do on its own.
But you just said that you look to the substance, not the label. That was your point.
Well, the point is that the motion, looking at the substance of the motion, it goes to not the sufficiency of the complaint, but it argues in effect a motion for summary disposition citing to the subsequent reassignment. So the trial court has authority under the small claims court to look at the motion, look at the record, and then enter its ruling.
So if I move to dismiss and say I move to dismiss for failure to state a claim because of this affidavit that I adduced, because I adduced an affidavit and attach it to the motion, that motion, even though it was asserting dismissal was warranted based on a failure to state a claim, the substance of it is transformed into a motion for summary judgment.
If the opposing
just because I attached an affidavit and that's what we usually do at the summary judgment stage.
If the opposing party at the proceeding upon that motion concedes to the authenticity of that affidavit, and then the court considers it and then makes its ruling, I do think that there should be an exception made in that.
Well, here's another problem with that exception, Mr. Schulte. Looking at the ruling on appeal, did the court below purport to make the change that you are now advocating? In other words, did the court say this is a summary disposition, or did the court do what the motion asked, which was dismiss?
The court did dismiss. The order does say dismisses. There's no transcript of the hearing. but the order also specifically states that it reviewed the motion and the filing of records and heard the arguments of counsel. And in the order, it specifically states that the authenticity of the second assignment was not disputed by the plaintiff. So I do believe that the plaintiff has waived the argument that they're trying to present here procedurally.
So let me make sure I understand this, because nowhere in the motion are the words summary disposition stated. Nowhere in the ruling are the words summary disposition stated, but we should nevertheless consider this a summary disposition.
Yes, because prior to the subsequent entry of the order, the motion was renewed, and it was renewed as an alternative motion for summary disposition. It went to a hearing, and then the trial court entered the order that's on appeal now. And that motion for
Wait, go back,
Certainly.
say that again. You appealed an order that granted a motion to dismiss.
The appellant,
And right, that granted the motion to dismiss. And we asked you all to show cause why it shouldn't be dismissed as from a non-final, non-appealable order. So we relinquished so that the appellant could obtain a final order, which just meant that the court, when it entered a second order, put in the language of finality. Are you trying to argue that that second order was a new ruling
Your
on
Honor,
the motion to dismiss?
I don't have the transcript of the hearing. There isn't a transcript, and I can't get into the court's head when they entered that order. I can just go from what's on the face.
Because
of the
we
order.
didn't relinquish jurisdiction for reconsideration.
Again, I can't state to what the basis was of the trial court's ruling apart from what's contained in the
Well,
order.
you're arguing something.
I am
I'm
arguing.
trying to understand your argument.
The argument that I'm presenting is the tipsy coachman argument that there is a basis in the record that was injected into the record by the appellant authenticating the reassignment that's at issue in the motion to dismiss, and that this court.
Well, but as I understand their argument, even if it's authentic, they're saying it applies to something, to other services.
And the issue with that argument is that looking at the face of the assignment agreement, it specifically states that it applies to past, present, and future rights relating to the services, the claims,
Yeah, but which
and the AOB.
services? Which services?
Well, it goes on to include the AOB, Your Honor. It states the AOB. On 608 of the
No,
record.
I've read it. I've read it.
So it's not just limited to the services, it also
Well,
specifically.
let me
states
ask
the
you another
AOB.
question. Your motion is a motion to dismiss based on standing. But if you look at the complaint and the assignment, they clearly have standing. Just looking at the complaint. So you have to look beyond the complaint to determine they don't. But it seems to me your argument isn't really standing. Your argument seems to me more like a defense to having to pay this claim. I don't know if it would be we already paid it or this or what. I mean, it seems more to me like just a defense to payment, not that they don't have standing. They have standing, but you're disputing whether or not this has already been paid.
The position is that the reassignment by the appellant extinguished the assignment. So there's nothing that gives them standing to even seek damages from the appellee.
So if it's a standing issue, that's a defense that needs to be raised and then adjudicated. You can't get a motion to dismiss based on standing.
But
or lack of standing, I should say.
But we have the alternative entitlement to that under the small claims rules under summary.
But you never even put the issue in play. Except by a motion, which you're asking us to reconstrue as something that it didn't say it was.
The position of the appellant is that the trial court was empowered to do that under the small claims court, and this court is also empowered to do that based on a review of the
It was
record
empowered
and
to
the
raise a
motion.
defense that had not been raised by the defendant?
No, the small claims court, the trial court below, was empowered to look at the record, look at the filings, and enter the order that it determined to be appropriate. And the analysis of the trial court is contained in the dismissal order, where it specifically cites the stipulation.
Well, look, let me just stop you. I understand that argument. Where was AQA put on notice that, hey, we're going to do this. We're just going to dispose of this case right now.
In the body of the motion, when it was set for hearing, subsequent to the initial pretrial conference by the small claims court.
Where? Point to me what you're referring to.
In the record, there's an initial pretrial conference, and then there were a series of subsequent conferences where the defendant's motions were brought up. And that subsequent hearing is the time in which the small claims court was entitled to enter the summary disposition.
No, but where, I'm asking where, when was, how, where in this record can I look and say, oh yeah, AQA was on notice that we're going to ultimately, the ultimate disposition of this case when we go to the next hearing?
The word summary disposition did not appear until the amended motion to dismiss / motion for summary judgment was filed between the times of the initial motion and the initial order granting and the second order.
Yeah, well, I you know, my view of that is anything after the initial order is not before us. So I'm not speaking for anyone but myself, but I don't think that helps you.
Understood, Your Honor.
Go ahead.
What I wanted to point out is that the assignment agreement itself specifically states that it incorporated the second assignment agreement incorporated the original assignment into it. The document also included that it assigned all past, present, and future rights, not just in the services or the claims, but also the AOB itself. In addition, the record below shows that the following fact pattern is what transpired. The appellant signed the initial assignment. Then subsequently, they did the second assignment to the factoring company. Then through counsel, the factoring company presented the claim to the appellee. The appellee resolved that claim and obtained a release from the factoring company. And the attorney for the factoring company was the exact same attorney that represents the appellant in this case, who has filed their amended statement of claim. In addition, the point is the court was asking when the assignment, the new claim for the engineering invoice was presented to the appellee, and that's in the record in the affidavit of Mr. Richie Kidwell. In his affidavit.
Wait. You're getting into things that were not in front of the trial court at the time it granted the motion to dismiss, right?
Correct. It's subsequent to the initial motion that was put in the record.
Which is what is in front of us. That was the order that was appealed. Correct?
Okay, so prior to that initial order, there is no record of when that invoice was presented to Florida Farm Bureau.
Okay.
And the argument of the appellee in this case is that the small claims rules are informal. They're supposed to lead to the swift disposition of this case. The order itself shows that the court considered the factors and weighed it and came to its ruling. And on that basis, the decision below should be affirmed. And that's the relief that the appellee is seeking in this case.
Okay, thank you. Mr. Barr, your rebuttal.
Wanted to address the question I told you I would address. I didn't see anything in the record indicating the actual date of those services. But I would just reiterate that the question that this all arises from demonstrates that this issue should be resolved at a summary judgment. This was a summary judgment proceeding.
Yeah.
And unless the court has any other questions for me, I will rely on the arguments in the briefs.
No. Anyone? All right. Thank you both.
Thank you.
That concludes this argument. All right. Next this morning, we've got Bell Transport